5 seconds to go. Start. In the said complaint, it was stated by Sarvesh Tiwari that he is a resident of Sagra village and he works as a property dealer. He has alleged that on 8th May 2020, the brokers of the land belonging to Ram Prasad Pandey, being accompanied with the others named in the complaint and being armed with illegal weapons, came there due to previous enmity with the intention to kill them, started indiscreet firing on the complainant and the others present. His cousin brother sustained gunshot injuries and fell to the ground. The attacking party had presumed them to be dead and went away abusing them. In that view, the complainant sought action against them. The said crime number 407 of 2020 was registered under section 307 IPC. In the second set of appeals relating to the said FIR number 407 of 2020, the persons accused therein, namely Lakshman Prasad Pandey, filed petitions before the High Court under section 438 of IPC seeking grant of anticipatory bail, which came to be rejected. The rejection of the anticipatory bail by the learned single judge is assailed in the second set of appeals. As already indicated, since all the above noted appeals arise out of the same alleged incident dated 8th May 2020, and the nature of consideration would be the same in all these cases, they are considered together. We have heard Mr. Siddharth Luthra, learned senior counsel, along with Ms. Sakshi Kakkad, learned counsel for the appellants, Mr. V.K. Shukla, learned senior counsel for the state of UP, and Mr. Sameer Kumar, learned counsel for the private respondents in all these appeals. The learned senior counsel for the appellants has taken us through the contents of FIR number 406 of 2020, and in that light has pointed out to the post-mortem report dated 9th May 2020, wherein the contents reveal that Ram Prasad Pandey, the deceased brother of the complainant, had suffered external injuries such as wound caused by a firearm. In that light, it is contended that when the case registered against the accused is for the grave offences which include the offence under section 302 IPC and the provisions of the Arms Act, the learned single judge ought to have appropriately recorded his satisfaction before exercising the discretion to enlarge on bail. It is contended that in the instant case, the learned single judge, except referring to the rival contention, has not analyzed the same for recording his satisfaction. Observations of a general nature is made and ordered to enlarge the accused on bail. It is contended that such consideration is contrary to the position of law enunciated by this court in the case of Mahipal versus Rajesh. The learned counsel had also made detailed reference to the other material on record to contend that the order to enlarge the accused on bail in FIR number 406 of 2020 is liable to be set aside insofar as the appeals filed by the accused in case relating to FIR number 407 of 2020, Mr. Siddharth Luthra, learned senior counsel appearing for the appellants therein, contended that the said complaint is filed only as a counterblast. It was an afterthought and filed as late as on 12th May 2020, though in the FIR the alleged offence is registered under section 307 IPC as well. The medical certificate relating to Anand Tiwari who is stated to be injured as per the complainant, had suffered only simple injuries caused due to hard and blunt object. In such event, when the persons named in the said FIR are available to cooperate in the investigation, the petition filed by them seeking anticipatory bail ought to have been appropriately considered by the learned single judge, and anticipatory bail ought to have been granted. It is further contended that the receipts dated 28th May 2018 and 29th June 2018 would indicate that Sarvesh Tiwari had received a sum of rupees 3 lakh from Lakshman Prasad Pandey, which was to be returned. He and his brother were attacked when they legitimately sought return of the money. Stop.